time. Very warm welcome to you. We hope these webinars are a helpful resource to share with you some what we think is some must-know information and guidance on different topics that we think may be of interest for you in your businesses and organisations. And you can catch up on recordings and slides for our previous webinars by heading to our website and clicking the link for the resources page. And you'll find there the webinars from our lawyers on all sorts of topics to do with property law, commercial and business law, estate planning, employment law, and of course, disputes and litigation, which is our theme for today. So today we'll be looking at situations where perhaps through no fault of your own, you've been brought into somebody else's dispute and asked to hand over documents and other information. And perhaps that might be something to do with your client or perhaps a former client or some other situation that's arisen. Sometimes these requests might be informal. You might just get a letter or something from their lawyer, but sometimes you might even find yourself on the receiving end of a subpoena from a court. So today we'll share some pointers on what can happen in these situations and how you should deal with them if you do find yourself in the middle, including what you might be able to do to claim some costs of complying, depending on what the situation is as well. So I'll shortly hand over firstly to Vash Naidu, my colleague here, who will start taking us through today's content. Vash is one of our litigation lawyers, along with Caroline Caligari and Kevin Lee. This is an area they're all very familiar with, and I know they're looking forward to sharing their knowledge with you today. So before we get started, I'll run through a couple of housekeeping items. We are obviously in webinar mode, so your cameras aren't visible, don't worry. And we are recording the session, so it will be available on our website afterwards, and we'll make sure you know when that has gone up in case you want to go back and look at anything again. And if you do have any questions throughout the session, please feel free to type away in the Q&A box. We'll try to get to some questions as we go along, and we've also got some time at the end. And we are conscious of the time though, so if we do run out of time and we aren't able to get to your question, don't worry, we will get back to you afterwards. And we'll also share our contact details at the end too, so you can feel free to get in touch with any of the lawyers after today if you've got something you want to bounce off of them. So before we begin, we are lawyers after all, so we do need to put up some fine print. Needless to say, we can only give some general guidance in this session. Every situation is different, so it's really important to keep that in mind. And if you do find yourself in one of these sort of situations, do get some advice on what you need to do in that particular situation. So let's get started, and we've got a bit to get through today. As I mentioned, we're going to cover a few key areas which basically will fall under subpoenas and your obligations if you receive one. The grounds that might be available for objecting to produce documents that can come up from time to time, and you might have a good reason why you shouldn't or don't want to cooperate with that request. Sometimes that's possible, sometimes your options are a bit more limited, and also the costs that you might incur and be able to recover if you do have to comply with subpoena. So I'll hand over now to Vash, who'll start at taking us through with what is a subpoena. Thank you, Vash.
Thanks for that, Mitchell, and good morning, everybody. So what is a subpoena? A subpoena is a legal document issued by the court at the request of a party to a case. The role of a subpoena is to ensure transparency and fairness by bringing to light key information that may assist a court in determining basically the key issues in dispute or progressing an ongoing investigation. So as such, a party can request that a subpoena be served on you if you refuse or are unable of your own free will to give evidence or produce documents relevant to their case. So I guess, look, therefore, unless you are able to validly object to a subpoena, it will compel you to either produce the required documents to the court for inspection by the other party or give evidence at a hearing or trial to avoid legal consequences. Now, typically, subpoenas are issued to accountants, real estate agents, business owners, lawyers, but they can also be served on individuals or organizations. Thanks. Next slide, Mitchell. So there's typically there are four types of subpoenas that a court may issue, and each has a different function. So specifically, the first one would be a subpoena to attend to give evidence. This basically compels a person to attend to give evidence at the trial of a proceeding. The second is a subpoena to produce. Now, this compels a person to produce documents at that trial of a proceeding. The third would be a subpoena to attend, to give evidence and to produce. This compels a person to give evidence and produce documents at the trial of a proceeding. And the last one is a subpoena for production to the prothonotary. Now, this compels a person to produce documents to the court for inspection by the parties prior to the trial of a proceeding. Thanks, Mitchell. Next slide. So what are your obligations if you are served with a subpoena? Now, if you're served with a subpoena, there is a notes section at the back of the subpoena that will provide information on what to do if you have been served with the subpoena. So it's really important that you do check those notes on the back. Complying with a subpoena is not optional. So therefore, if you do receive one, you should take action immediately, whether that be to seek legal assistance or seek other forms of assistance as well. If there was a failure to properly serve the subpoena in the way that the court rules require, or conduct money was not provided, then this can form the basis for not complying with the subpoena. But again, it's always very important that you seek legal advice on whether the subpoena was properly served on you, because if you don't comply with that subpoena, there can obviously be legal consequences. So what is conduct money? Conduct money is money sufficient for return travel between your place of residence or employment and the court. The amount of conduct money must be at least $25. So if you're not given this money, it can be that you do not need to comply with the subpoena. So if you're having trouble complying with the subpoena, make sure to contact the party that issued it. Usually their contact details will be located on the front of the subpoena. So if you have any issues, make sure that you let them know. If you fail to respond to a subpoena or to appear in court as directed by the subpoena, then, as I said, there are some consequences that can happen. A court may issue a warrant for your arrest, order you to pay any costs caused by the non-compliance, or find you in contempt of court and impose a fine. Next slide. Thanks, Mitchell. So how long does a subpoena remain in force? A subpoena remains in force until the first of the following events occur. That would be the person subpoenaed complies with the subpoena, or the issuing party or the court releases the person subpoenaed from the obligation to comply with the subpoena, or the hearing or trial is concluded. So basically, when you're served with a subpoena, ensure that you read the subpoena carefully to ensure you understand its scope, purpose, and the specific actions required of you. Respond within the given time frame. If there are any grounds to object to the subpoena, then you can obviously challenge the subpoena if appropriate. If the subpoena cannot be challenged, then ensure that you comply with the specific demands, whether that be testifying in court, producing documents, or providing information. Another obligation that you need to ensure that you comply with is that subpoenas require you to preserve all relevant documents and information. So this can include your physical documents, electronic files, emails, or any other materials. So it's also important to remember, if a subpoena comes with instructions to maintain the confidentiality of the documents or information provided, then it's important that you do adhere to these instructions as well. And remember, the specific obligations may vary depending on the jurisdiction and the nature of the case. So it's always best to seek legal advice if you have been served with a subpoena. Now, on the next few slides, there are some practical examples as well. So you can see here, for employers, if they have been issued with a subpoena, it may be for payment records for an employee in a family law proceeding, or for a human resource file, which could contain disciplinary reports with privileged or confidential documents or personal data about other employees. For business owners and entities, that may be for financial records where it was thought the employee of another company may have been acting on his own behalf, or for data about how much it pays certain high-level staff for an expert to give a report on remuneration in the industry. Next slide. Thanks, Mitchell. Law firms may also be issued with subpoenas for an advice file where their former client is in a dispute, or for a will file in an estate dispute as well. And accountants may be issued with a subpoena for company documents or information in a shareholders oppression case. And finally, we've got real estate agents as well that may be issued with a subpoena acting where they've been acting for a mortgagee in possession, asked to produce their campaign file to ascertain whether the mortgagee acted in default of its duty as mortgagee in possession, or to seek to establish whether the sale was for undervalue. Thanks, Mitchell. So I'll just pass over to Caroline to take you further through the presentation.
Yes, I was going to say it's my turn now. We're now covering what are the reasons you can object to producing documents under a subpoena. Now, we have been focusing on subpoenas in this presentation in our slides, but the ways or the things you need to think about apply equally if you've just received an initial letter asking for documentation, or if you have received what is sometimes known as a letter asking for preliminary discovery in a proceeding, where somebody or the other side is trying to establish whether they have a case, or they bring the actual application for preliminary discovery against you. The matters we're going to raise now are all things you need to consider at the time you receive it. Now, a subpoena you have to comply with. A letter requiring you to produce documents don't necessarily have to comply with, and your first thought should be, do I have to comply? And if I give over these documents, is this going to cause trouble for either myself or my clients or customers whose information that they're seeking from me? And I would consider those letters with a grain of salt. And, this is not me trying to get work here. If you get a letter and not a subpoena, you should probably consider speaking to a lawyer, even if it's a 5-minute call, just to see, what should I do with this? Do I have to comply with it? How can I respond? Is there something, maybe I only give them some of the information, or I talk to them but don't give them documents, etc. To see whether there's a way you can comply but not find yourself at risk.
The other situation that, sorry to interject, is that can come up is if, depending on what you do, you might have certain confidentiality obligations and things like that, where you might be concerned about breaching that if you just handed it over based on a letter. But sometimes waiting until the other party actually goes to court and issues a subpoena can provide some protection, can't it, Caroline? Because you're having to comply with the court ordering you to produce that material rather than you just voluntarily handing it over when you've received the letter.
Yes, and it's generally better to hand over documents pursuant to a subpoena because you're being compelled by the court. So you're given some protection for producing documents, and the other side's given, so your client is giving an opportunity to object to anybody actually looking at the documents. Whereas if you just hand it over, you're not covered by those protections, which is why we say if you get a letter, it's probably better to seek legal advice before you hand anything over, just to be sure. Now, the liability issues for you to consider, either when you get a letter or a subpoena, are listed here in this slide. So, and we'll go into each of them in a little bit more detail after this. Consider whether any of the documents are privileged. So, have you been given documentation when legal advice has been provided, or been involved in assisting your client to provide instructions to a lawyer as part of an ongoing dispute? And this is the dispute that you're being asked for the documents in. Are any of the documents confidential? Are they confidential to you and your business? Or are they confidential to your customer's business or between certain people? Are any of the documents commercial in confidence? So the practical examples that Vash mentioned and that were on the other slides are actually examples where I've been involved in where there's been a subpoena. And sometimes it does involve third parties issuing against kind of another third party in the industry for information about, charge out rates and how much a director's being remunerated, which is something that's confidential to you and your organisation, and you don't want to be out there in the public sphere. And the minute you put it to court, it's in the public record unless you do something to keep the confidentiality of the material. Do the documents disclose private information? Many organisations are subject to the Privacy Act, and your document might produce information about the client or the person in the proceeding. And if they've subpoenaed you, well, they're okay with their information being produced. But what if it involves other people in your organisation who you've got a duty of privacy? What if it's got their addresses in there or details of their bank accounts? You need to think about that information when you receive one. Or is there any other legislation like the Privacy Act preventing disclosure? Again, I've had practical examples where maternal child health nurses have been subpoenaed for children's files in child protection disputes, and there's been confidential reporters, and in that of child abuse. And in that case, the Children, Youth and Families Act applies. But I mean, you might have somebody in your organisation who's given a confidential report in relation to a family law dispute and is being subpoenaed. So you do have to carefully think about these things. Next slide. Why? Because there's risks for you. Even though a subpoena compels you to produce documents, there are still risks for you if you just produce the documents without thinking about these issues, and at the very least having a discussion with your customer or client or supplier about whether they would be happy or not with this information being out there in the public. This is especially so where you're an advisor, because at this point in time, there starts to be a clash between, you know, your duties as the advisor and your contractual obligations to your clients and customers versus this subpoena, which is compelling you to produce documents to the court. And given there are ways to protect the information, like getting confidentiality orders or objections, you do need to think before you just hand things over. You can't just say, I have a subpoena, I'm just handing it over unprotected, because you're not protected in all circumstances. The thing is, even if you don't have legal liability and you're protected by the subpoena, you could still hurt your ongoing business relationship with your client, your customer, or your supplier if you don't actually consider these issues or speak to them and let them know that you're going to be handing over the documents so they can consider what they might want to do to prevent them from being disclosed. Now into the nitty-gritties of each of the particular topics. First one is privileged. So what is a privileged document? It is a confidential communication or a confidential document between a lawyer and a client made for the dominant purpose of the lawyer providing legal advice or professional legal services to the client, or for use in current or anticipated litigation. Now, often advisors get caught up in here because you might be the accountant. There might be a dispute which involves a summary of the financial information so that we work out loss and damage, and you've been in contact directly with the lawyer in relation to that dispute in providing the information, talking them through it, helping them understand, so the lawyer can then prepare the case for their client. Those communications are privileged, and sometimes a subpoena is wide enough that it covers those communications. So then you need to consider the issue of privilege. If you think you've got privileged documents, then here's the things you need to kind of think about and do. First one is advise the client or privilege is not yours. Privilege is the privilege of your customer or the client. So advise them that privileged documents are being sought and that you need to comply with the subpoena. And they might say to you, well, I'm going to lodge an objection. Or they might say to you, you know what, I don't care. I'm happy for you to produce them. I waive privilege. Get that in writing from them. If your communication was directly with the lawyer and helping them in the legal dispute and providing them information for them to draw the pleadings or prepare reports or prepare witness statements, etc., then speak to that lawyer, because they might then take steps to do something in the proceeding and be able to give you some guidance on what to do at that point in time. Some repeats here. If you've got to really work out what your client or the lawyer wants to do. Do they want to waive privilege or claim privilege? If they want to waive privilege, then you don't have to worry about putting the documents in a special envelope, etc. If they want to claim privilege, then the question becomes, is it you who is going to be claiming the privilege on their behalf and getting them to and putting in an objection? Or are they going to put in an objection, and how's that timing going to work practically? That's why when you suddenly have privilege issues, it's always good to get some legal advice from an independent third party like us, so we can guide you through these steps. The other thing is you can always sometimes negotiate with the other side as to whether or not they're happy for you not to produce privileged documents, because sometimes their their scopes of their subpoenas are so wide that they haven't actually thought about whether or not privileged documents are covered, and they don't actually want to see the privileged documents. Sometimes they want to see them, and that's why they issued a subpoena. Sometimes they don't. So you could negotiate with them and say, look, this category of documents is so wide, it captures privileged documents. Are you happy for me to exclude them from production? And then you get them to, and that's called clarifying the scope of the subpoena. And if you get them to do that in writing, then again, you're protected if you don't produce the documents, and it might avoid you having to go look for them and produce the documents. If those negotiations don't exclude the privileged documents, then you still need to produce them, but you should produce them separately in an envelope that is sealed and that is clearly marked privileged documents. You would produce them along with an objection to protect the privilege if you're the one who's going to be making the objection on behalf of the customer or the client, or on behalf of yourself, because it might be your own privileged documents. Or if you know your customer's going to be there, they've got their lawyer involved and they're going to be lodging an objection, then you have a cover letter to the court which explains that you've produced two separate sets of documents. The ones in the thing are privileged, and you understand that X, Y, and Z in the proceeding is going to be lodging an objection, and you ask the court not to allow production until that objection's been heard. Next slide, please. Now, the process when you're considering privilege is a similar process for confidential documents. But the first thing is, what's a confidential document? I should say, and I probably should have said this at the start, the first thing to consider when you've gotten the subpoena is what is the scope and what documents is it asking you to produce? You don't just start collating the documents, you think about what they're asking for, and then you think about these issues. Now, a confidential document is a document which contains confidential information such as trade secrets, intellectual property details, confidential contracts. So it might be asking you to produce a contract that has a specific confidentiality clause. Maybe it's documents that you're being asked to produce that you only got as under an NDA and you're subject to the NDA, or the like. Now, again, if the confidential information is relevant to the issues in the dispute in the proceeding, then you have to produce them. If they're not relevant, however, you might be able to either lodge an objection or seek to have parts of the subpoena struck out and an order made by the court that you don't need to produce the confidential information. You can also apply, no, we're still on there. You can still apply to the court for limits on what is disclosed or how much is disclosed, or come to a confidentiality regime with the other side in relation to what you produce or not. So, for example, they only might want a certain bit of information out of those documents. They might be happy for you to redact the confidential information when you produce it. And then, of course, your cover letter to the court explains that, you come to that deal. They might agree to a binding confidentiality regime with you so that you're producing the documents on the basis that this confidentiality regime will be put in place either by orders or by a signed agreement between all the parties, where only those documents are produced to the lawyers and the experts on a confidential basis, and that before documents are used in the court proceeding, the court gets an order that they're kept confidential and that they're sealed so that it's not on the public record. Or you might yourself, if you can't come to a confidentiality regime, lodge an objection or apply to the court for confidentiality orders. Again, if you're going to produce confidential documents, you want to put them in a separate envelope marked confidential, especially if they're going to be subject to a separate regime. Another thing to think about is the privacy legislation. Now, the below is relevant if one of the Privacy Acts applies to your organisation. We're not going to go through does the Privacy Act apply or not. But if it does and you hold personal information about an individual, then you must not use or disclose that information for any other purpose unless the individual has consented or an exception applies. Now, a subpoena does provide an exemption as its disclosure provided by law, but you still need to consider whether the personal information is relevant to the proceeding, because if it's not relevant, then you're not covered by the exemption. And so you might want to object. Or can the personal information be redacted in some way? And again, that will involve a discussion with the other side, or you might just redact it. So for example, in the other legislation category, where there's been information about a confidential reporter, you redact it so nobody can find out who the name or the contact details of the confidential reporter. You redact anything which might give an indication as to who that person might be, like dates and times of visits, etc. And then you lodge that information with the court redacted with a cover letter which explains, you know, the basis on why it has been redacted. So these are effectively your three options when you're issued with a subpoena and you have concerns. It can be the concerns about whether there's privilege, confidentiality, privacy, etc. It can also be if you have concerns about the width of the subpoena, whether the documents they're asking for are relevant to the issues in the dispute, whether, you know, they're basically, it's a phishing exercise and they're asking you to produce hundreds of thousands of documents and they don't actually realise. Your first step is speak to the party who subpoenaed you about the scope of the subpoena and exactly what they're asking for and whether they're happy either clarifying the scope of the subpoena or limiting what you produce or how you produce it. Like they might be happy with you redacting the documents. If you have concerns, this is a stage where it's actually good to get a lawyer involved to help you in those negotiations because we know the issues and we know the different ways you might be able to deal with it. And we can look at the documents that you're considering producing, give you advice on whether there's a risk, and then give you an advice on how practically you might present it to the other side to avoid you producing what you don't want to produce, or at least producing it in a way that protects you. If you can't come to an arrangement with the other side and you still have to produce the documents, then you produce them, but under cover of an objection. That's if it's a subpoena. If it's, you know, a letter, well, you just don't produce them. If it's a preliminary discovery application, then you don't produce them until the application's been heard and you run your arguments before the court in that preliminary discovery application as to why they shouldn't be produced or why they should be produced in a certain way. And ultimately, if you dispute the subpoena itself in its entirety, so for example, you think it is asking for completely irrelevant information or it is completely a phishing expedition, and these things are going to be dealt with in a little bit more detail by Kevin next, that, you know, they're just trying to find a needle in a haystack, or there's like hundreds of thousands of documents that you're going to have to produce, which is going to require like a year of you having, I'm exaggerating here, of course, you know, months of your employees sitting in a back room going through documents to work out what should be produced under the subpoena, and to look at privilege and confidentiality, then you might actually make an application to have the subpoena itself set aside. And in those circumstances, if you're going to make an application, you won't necessarily produce the documents. I mean, if it's going to take you 6 months to produce the documents, then you're not going to do that and then produce it all to the court and make your application to have it set aside, because that just defeats the purpose of having it set aside in the first place. But again, if you're going to try and make an application to set aside, it's important to get legal advice at that point in time so you can determine whether you're actually going to produce or not produce, and you at least put on the record to protect yourself why you're not producing it, and you make the application within the required time to protect yourself. I'll move on to Kevin now, and he can cover the grounds for setting aside a subpoena and when you might consider them.
Thank you, Caroline. Good morning, everyone. So apart from objecting to a subpoena, there are also an avenue to set aside a subpoena on sufficient grounds. So subpoena cannot be issued basically for any other purpose, but for legitimate forensic purpose. So that's the ultimate test when a court considers whether to allow the objection or to set aside a subpoena either in its entirety or in part. So the consequence of setting aside subpoena is that the subpoena party will no longer be required to produce the documents as required under subpoena, or if that's set aside in part, then that means the part that has been either set aside or struck out, you are no longer required to produce the documents or the things under that particular part. So what does it mean by legitimate forensic purpose? There are a number of factors that the court would usually look at. Would be the following. As Caroline mentioned before, the documents required has to relate to an issue in the proceedings, so it has to be relevant. Now, the test for that is a rather low threshold. Apparent relevance would be sufficient for the requesting party to overcome that hurdle. In legalistic term, we will usually call that a prima facie relevance. So as long as they can establish that it relates to an issue in dispute, the other side, that the requesting party would be entitled to that document. However, the subpoena cannot be impermissibly broad, so they have to confine their scope of request to a reasonable degree. And it cannot be a fishing expedition, meaning that they cannot be shooting in the dark and trying to get documents that they do not know whether they would exist, or they know they exist, but it has a marginal relevance. And it cannot be too oppressive or otherwise constitutes an abuse of process. Now, what does that mean is that it may constitute an abuse of process if the subpoena does not actually specify the documents with reasonable particularity, such that the subpoena is effectively asking for discovery from the non-party. And it may be too onerous if you're required to go through the entire archive of documents, and you'll be spending a lot of time to retrieve those documents. Lastly, you can also set it aside if the documents requested would relate to public interest, immunity, or privilege. These documents would usually concern the state of defense and also foreign affairs of the state. So you can also try to set aside on those grounds. This list here is by no means exhaustive. So there are other factors that the court may look at if an application for setting aside is made to the court. Next slide, please.
I might just quickly jump in there. One of the things to consider when you're looking at oppressiveness is that subpoena asking you to actually make forensic decisions about what to produce and what not to produce? And are you left kind of hanging as to what they're asking for? If you're left hanging as to what they're asking for, and it seems so broad that you need to make decisions as to what is or isn't covered by the subpoena, then that's kind of a little light bulb moment for you to think, maybe this is oppressive. Maybe it's a fishing expedition. Maybe I can get this set aside and I should get some advice at this point in time.
Yeah. Thanks, Caroline. So the next slide would be about cost of compliance. So that's also another reason why you would usually wait for subpoena before you produce any documents, as opposed to just a letter from the other side and you voluntarily produce the documents, because apart from the legal protections that you would get under subpoena, you also obtain the protection on costs. Because if you have to comply with subpoena, obviously you will have to incur costs either on behalf of your client or on behalf of your entity. And you would like to retrieve the costs expended in this exercise. So the court would usually, they may order the issuer to pay reasonable loss or expense incurred by the receiver. The phrase to pay reasonable loss or expense is nothing more than just a reasonable cost. The courts have found that the phrase means nothing more than that. So this amount is separate from, and in addition to any contact money paid to the addressee. The contact money has been addressed by my colleague Vash. As you remember, the contact money is actually quite small. It's only $25 or above. But as we could imagine, going through this stack of documents just to compile them would cost a lot more. So that would be the cost to cover production of documents and also any other witness expenses if you are required to attend court to give evidence. And if the amount that you expect to incur in the exercise is going to be huge, or is going to be quite a bit, it would be advisable for you to inform the other side before you embark on the exercise. This is not only to protect you on cost, because when the court they have to consider an application for reimbursement on cost. They would also look at the pre-action letter before you incur any extra costs or excessive costs, because there have been cases which say that the failure to writes this letter to the issuing party will actually disentitle the applicant from claiming the amount, and vice versa. The failure to respond to a letter on cost from the subpoena party may actually allow the applicant to claim the cost stated in the letter, because the court would deem that to be a reasonable request. And the fact that you failed to respond to it would mean that you sort of acknowledge the reasonableness of that amount. So in allowing application for cost, the court would consider whether the cost incurred is reasonable. The rationale behind that is it's very straightforward and simple, because the subpoena party is usually the non-party in the litigation. And of course, as a non-party to litigation, they should not be asked to bear any part of the cost of the proceedings. And that's why they should be compensated for that reason. And they should not be kept out of pocket. So ASADA would be the authority on that principle. And the word reasonable within the phrase reasonable loss or expense incurred can refer to both the category of expense and also to the amount of the cost. So the category of expense would cover what kind of exercise that you have to embark on, and also the cost for that particular task. So that would be the amount. And ultimately, it would be a discretion of the court as to the category of costs allowed, and also the actual amount of costs allowed in the application. And the courts would usually adopt what we call a broad brush approach in determining that. Thank you, Mitch. So these are the examples of costs normally allowed in an application. And that would cover the legal advice. And obviously, if you receive a subpoena and you are not a lawyer, you would obviously need some legal advice on either the request, on the validity of the subpoena, on the scope of the subpoena, and whether you can take objections or even set it aside. So this category of costs has been considered by the courts to be a reasonable expense. As long as they are reasonably incurred and the amount is not excessive within the reasonable range, this category of cost would be allowed by the court. And the third bullet point here is that when the recipient, say for example, you are holding some documents, you're in possession of some documents of your client, and obviously you will have to go back to your client and consult with them. Caroline has touched upon the privilege part and confidentiality part. So you may have to consult a client as to whether they are willing to produce these documents. And that part of the cost would be also be covered by the reimbursement order. Next slide, please, Mitch. And there will be some other general costs, including, say, for example, printing, copying, getting a USB or external hard drives to store the documents. And you may have to go through your archive documents just to make sure that the documents are there and they are disclosable, and also third-party costs involved in that process. And it will also cover employees and also fee earners' expenses. And that would cover, include employee on costs and actual charge-out rate of a fee earner. So that's some good news for professionals, for example, like lawyers, accountants, or other professionals who are charging on an hourly basis. And for corporations, if your corporation has to particularly employ someone else to conduct that particular task of retrieving documents and compiling them and to produce them to the requesting party, then the wages that you pay to that employee would also be compensated. And for firms or partnerships, because the fee earners, the professionals in those entities would be charging on an actual time cost basis, and that would also be recoverable from the requesting party. Mitch. So I've covered the part about production of documents. Now, if you are required to attend court to be a witness and to testify, then obviously the cost would cover the attendance per diem. And if you're a professional, you'll be also able to charge on an hourly basis. And that would also cover travel expenses, accommodation, or meals. And if you have to go to a regional court to testify, you would be able to charge on a higher rate as well. And I have attempted to provide a summary of the figures, the cost on the cost scale. And what I've not included is the county court scale cost, because we don't have enough space for this slide. But you can sort of speculate the figures and the rates would be somewhere between the Magistrates Court and also the Supreme Court of Victoria. And you would know that the rates given by federal court are somewhat surprisingly lower than the other courts. So the last slide here would be the cost for setting aside a subpoena. Now, there should be a distinction between the cost for complying with the subpoena and the cost for setting aside a subpoena. Now, the former would usually be covered as long as the costs are reasonable and the amount is reasonable as well. However, the cost for setting aside a subpoena would probably be considered by the court as a strategic move by the recipient. That part of the cost would be separately determined by the court as to whether that should be granted. Again, it's discretionary, and the court would look at whether the application to set aside subpoena, should you fail. Well, if you fail in the application, normally you wouldn't get costs. But the court will also go beyond and look at it and see whether the application in the first place was reasonably made. If that's reasonably made, even though if you fail, you may be able to get some costs. But again, just like any other litigation, the cost that you ultimately get for this application would not be 100% of the cost incurred. Would be taxed down, usually according to the cost scale. Thank you, Mitch.
Great, thank you very much, Kevin and Caroline and Bash. That's sort of the end of the content, everybody. So we do have some time for some questions. As you can see, it's perhaps a deceptively simple area. May seem quite straightforward if you get a request, especially from a court. You've got to follow that and to the letter, but ain't necessarily so, depending on the situation and depending on what you're doing in your business and the type of documents that are being sought. Quite a bit to unpack and consider before jumping straight into complying with that request. So.
I'm also going to say it seems straightforward on the cost that you're going to get your reasonable loss and expense, but it's also not an excuse for a blank check either. And that's often, you'll comply with the subpoena, you'll come to an agreement with the other side about what you're going to produce, but there's not quite an agreement of costs, and you end up having a fight about the reimbursement in relation to the same. So that's why we always say, write that letter at the beginning, or get your lawyer write the letter at the beginning. And if you think your costs are going to be, substantial costs, let the other side know, because they might say, oh, I'm going to be at risk of paying you, for example, $20,000 to go through all these documents. They might withdraw the subpoena, and then you might not have to produce the documents.
When we're involved in giving some advice, we can certainly give an indication of what sort of likely costs might be and what you might be able to recover. So thank you very much for the comment, Stephen. We don't have any questions, so we'll wrap things up there. But we do have our contact details at the end, so feel free to get in touch with Bash, Caroline, or Kevin, or myself if you do have any issues that come up from time to time. And we do publish articles on this sort of stuff and other topics to do with litigation and disputes on our website there. If you go to the blog section, and as well as on our social media, we post them and share them as we go along. So we do have another webinar coming up next month. We'll come around quickly on property law and leasing, carrying on from our leasing webinar earlier on in the year. So we'll share some more details of that soon. A reminder too, if you don't mind me giving a little bit of a quick plug to Fighting for Enterprise Success Through the Eye of the Tiger by David Sharrock, which really is an excellent workbook, really, if you're wanting some input into how a systems-based approach can help drive enterprise success in your business or organisation, with a lot of personal reflections and input from David, of course, as well as a lot of material that we've shared from our own business, which may help in terms of templates and checklists and things of that nature. So I do recommend having a look at that website if you haven't had a look before and you're not familiar with it. So that does bring us to the end. Thank you very much, everybody, again for joining us today. We hope it's been helpful and giving you some pointers. And as I said before, do feel free to get in touch anytime if you're wanting to bounce something off of any of us, or if you have any other issues from time to time as well. So thank you very much. That brings us to the end of today's event. Please, don't hesitate to contact us. And in the meantime, we wish you all the very best. Have a nice day. Thank you.